Good morning. Welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal in the matter of Harcus Sinclair LLP and Your Lawyers Limited. This is the second day of the hearing, and we're currently hearing submissions from Mr. Crowe on behalf of the respondent. Mr. Crowe.
Thank you. Yesterday, we were looking at the case law in relation to issue 1. I had taken you to Stevens and Hill. The other case law you saw yesterday, and I don't want to go through each of them, getting them back up on the screen, but can I just run through, because most of the relevant passages have been read, but could I just run through and emphasize, just by giving you page references, the particular passages where, if and when you are considering judgment, we would invite your particular attention, because these are the passages we say that support the analysis we're offering, which is that the relation to differentiating between a merely contractual agreement, which a person who happens to be a solicitor may enter into, on the one hand, and a solicitor's undertaking which attracts the court's inherent supervisory jurisdiction. The defining characteristic is whether the substance of the undertaking involves the provision of professional services. You saw Re G yesterday. When you go back and look at this, at page 1085, you will see the question posed, has the undertaking which it is sought to enforce been given by the attorney in his character of attorney in the transaction in dispute? Re Fairthorne, my learned friend also referred to. When you look at that one, you will see on page 1070, the question is posed of whether the attorney was acting in that character. When you go back to United Mining and Beecher, you will see those earlier case reports cited and quoted with approval, and at from pages 1989 to 1991, you will find an assortment of expressions, including the solicitor must be acting professionally. Quoting from G, the undertaking must be given by the attorney in his character of attorney, and paraphrased as undertakings professionally given, page 1991. You were taken next to Silver and Drake and Baines. We would invite you to pay particular attention to that, because it was a case in which one solicitor gave an undertaking to another solicitor in relation to the affairs of one of the solicitor's clients, and yet the court found it was not a solicitor's undertaking. And you'll see the expressions if you are reviewing at pages 1093 to 1096. You will again see a number of descriptive passages using expressions such as in the execution of their office, in his capacity as a solicitor, and in the course of his activities as a solicitor. You were taken to the John Fox case, and we would invite your attention particularly on page 1077, between letters C and D, which again refer to undertakings given in their capacity as solicitors, and undertakings given by them professionally. And the jurisdiction is expressed as being exercised by the court against its officers acting as such. Udall and Capri Lighting at page 1959, again refers to undertakings given in the course of their profession. My learned friend then mentioned, but didn't take you to two cases which he described as dealing with the authority question. And that is, you will have seen these in the parties' written cases. We rely on the United Bank of Kuwait and Hamoud. That was an appeal in which issues both of liability under the Partnership Act and by that route, questions of whether or not the undertaking was given in the normal course of practice, but also questions of whether or not the undertaking was properly classified as a solicitor's undertaking, were decided. And Lord Justice Staunton, at page 1977, lists out the tests for both those, the agency, the Partnership Act, and the solicitor undertaking question, and says they are essentially all the same question, involving the same tests. And what he asks is whether the thing was done in the usual way of business, of the kind carried on by the firm, in the usual way of business of the firm. And at page 1979, the expression is coined solicitorial services. And the final case it is Hurst and Etherington, which you will see at page 1257, uses the expression a normal part of a solicitor's business. Now, you already had yesterday my oral submission as to why we say the undertaking in this case is not to be classified as a solicitor's undertaking. And I hope by emphasizing the language used in those cases, that submission now falls into place. To recap, we submit that giving an undertaking not to act for clients is not the provision of solicitorial services. It's not the delivery of any professional service at all, and it is not something that is in any sense unique to the solicitor's profession. It is not in any sense a service given to a client qua client. It was an agreement in the context of possible advice being given by Harcus Sinclair to your lawyers. And in that sense, your lawyers were anticipated to be potentially a client. But the substance of the undertaking was not an undertaking to a client. It was a contractual agreement between competing business firms. And that's why we say it's not properly classified as a solicitor's undertaking. Incidentally, my learned friend sought to draw comfort from the use of the word undertaking in clause 2, and he said that connotes a solicitor's undertaking. We would just make two very short observations about that. The first is with respect, it's a non sequitur. An undertaking simply indicates a commitment. There is no disagreement between the parties that there was a contractual commitment. The dispute between us is over the proper legal classification as to whether it was or wasn't a solicitor's undertaking that attracts the supervisory jurisdiction of the court. As it happens, the use of the word undertaking came from your lawyers. They were the ones who drafted the NDA. It was not Harcus Sinclair saying, here is our offering to you. I mean, in law, it may well have been an offer. We'll come back to that. But as a matter of language, it came from your lawyers. And it was language they used equally when they were engaging with Mr. Fairley, who you remember was involved in potentially raising the finance. And exactly the same wording was used in the contracts they asked him to sign. We don't need to go to it, but if you're curious, it's in the bundle at page 2498. And he was asked to sign an agreement with essentially exactly the same contractual undertaking. So the suggestion that the mere use of the word undertaking somehow is indicative of the classification of this undertaking as a solicitor's undertaking in our submission is false logic, just as a matter of abstract principle, but also false by reference to the facts of this case. So if we can then just look very briefly with that analysis, very briefly at the first instance judgment to see why the judge came to a different view. And if we can pick up then his judgment starting at paragraph 206, which is going to be at page 260. Page 260, the issue 1 in this appeal effectively starts at paragraph 204, and you'll recall that his lordship had already decided by this point in his judgment that the supervisory jurisdiction, if it existed in principle, was not available against Harcus Sinclair LLP and was not available against Mr. Parker personally. And he then expresses his reservations at para 203 as to whether he should actually go on to decide whether or not it was a solicitor's undertaking at all, because he has already decided the answer to that question isn't going to affect the outcome. But he decides he will go ahead anyway, and he says that that's what he's going to do in paragraph 204. And what he does, first of all, if you look at paragraph 206, we can turn the pages quite quickly, from paragraph 206 through to 222, so going straight on to page 265, he rattles through the case law. Then at paragraph 223 and 224, he looks at the potential relevance of the then applicable SRA Code of Conduct definition of undertaking. And you'll see that that is set out. And he says at para 224, at first sight, that might be thought to be rather wider than the definition established in the relevant case law. But Mr. Coleman, in closing submissions, accepted that the references to in the course of practice and outside the course of practice, but as a solicitor, preserved the requirements that the relevant undertaking, in order to be a solicitor's undertaking, had to be given by the relevant solicitor in the capacity of a solicitor. So we get from those two paragraphs his lordship reaching what in our submission is the right answer, which is that the SRA definition of undertaking doesn't alter the analysis. And what he then does is to consider a number of submissions which are not part of the argument that we're advancing in this appeal, where counsel then instructed, suggested that there was a hard-edged rule, for example, that it couldn't be a solicitor's undertaking unless there was a transaction involving a client. And that takes one through paragraphs 227 over the page to 234. And if we can then pick it up on page 267, it's paragraphs 235 really to 237 that encapsulate the ratio of why the judge came to a view which we say is wrong. And you'll see essentially there are two elements in what he says. He says that the undertaking, and this is the tail end of para 235, second half, he says, in giving the undertaking, was the claimant acting in its capacity as a firm of solicitors? Putting the matter more precisely, was the undertaking given by the first claimant as part of a solicitorial service? And it's those words, those two words, as part of a solicitorial service, that led him into the error we say he made, because his analysis was that the non-disclosure agreement was signed in anticipation of Harcus Sinclair giving some legal advice to your lawyers, and that the undertaking, the restriction, the non-compete clause, was related to that. So the error he makes in our submission is very simply that instead of asking the question that the case law poses, which is, was the subject matter of the undertaking something that involved the solicitor providing professional services? The question he asks is it ancillary to something that the solicitor was doing in a solicitor's context? And that essentially is why we say he got it wrong. And it loops in, I think, with a question my Lady Arden asked yesterday along these lines. I think my lady put to me that it could be suggested that the undertaking was part of the build-up to an anticipated advice by Harcus Sinclair. And as I say, we have two answers. One is in a sense the clean legal answer, which is that is the wrong question. Our second answer, though, is even if you consider that the judge applied the right test and that it is appropriate to consider whether or not the undertaking was given somehow ancillary to the anticipated provision of possible solicitorial services, in our submission, there was not, in this case, a sufficient connection between the giving of this restriction and the provision of any genuinely solicitorial services, for essentially just a little package of reasons. First, as I imagine I've already tried to make clear, the non-disclosure agreement was just that. It was not a contract of retainer, and it didn't involve any commitment to seek legal advice. Yes, it is perfectly true it was signed in the anticipation that some legal advice might be sought, but it wasn't a contract of retainer, and it didn't involve any commitment either to seek any particular level or detail of advice, or indeed any advice at all. And so the undertaking does have to be read properly in the context of what the contract actually does embody. If one wanted to capture where the parties were at the point where the contract had been signed, there is an expression we've quoted, I think, in our written case. In paragraph 76 of the first instance judgment, we don't need to go back to it, but it's on page 229. His Lordship said everything was up in the air. There was no commitment to obtain legal advice. There was no commitment to collaborate. The non-disclosure agreement, as we urged on you, was just that. And so what happened next is irrelevant to the question of classification of the undertaking as at the time it was given. And we would also emphasize, I'm not going to go to it, it was part of your lawyer's case that they had no settled intention to collaborate. And that is clear, and we don't need to go to it, but they made that quite clear in their skeleton argument in the court below. If you look in due course, it's paragraph 88.4 of their skeleton argument, which is at page 2392 of the bundle. They positively assert that they had no settled intention to collaborate. And so, again, in that factual context, looking at what they say their intentions were and what the actual substance of the contract was, in our submission, even if one did adopt the judge's approach, I would say, of analysing, is it sufficiently close to the possible provision of solicitorial services? In our submission, it isn't. And so the last point I just wanted to make on issue 1 relates to the appellate function, because my learned friend submitted that the question whether or not the undertaking is a solicitor's undertaking is a question of fact, and it shouldn't be disturbed on appeal on the usual principles relating to findings of fact at first instance. We have a number of answers to that. The first is that if the judge applied the wrong test, then his finding of fact falls away in any event. But secondly, in our submission, the decision whether or not a commitment was or was not a solicitor's undertaking is not a finding of fact. I know that's what the judge said in Re Fairthorne, but with the greatest respect, it isn't right. And the way my learned friend was actually putting his argument gave the lie to it, because he repeatedly talked about the question of the capacity in which the solicitor is acting. And that is, with respect, right. That is the right question. The question of fact is, did the solicitor give the undertaking? Was it his signature on the page, or if it was oral, did the solicitor actually say that? That's the question of fact. The question whether it was or was not a solicitor's undertaking is a question of legal classification. And so in our submission, it isn't a question of fact. And as we've pointed out in our written case, the law reports illustrate the freedom with which appellate courts have reversed decisions of judges at first instance, not on points of primary fact as to who said what when, but on the question of classification. That's what the Court of Appeal did in the case of Silver, Drake and Baines, which you're familiar with. I'll just, to give you the page, it's 1087. And the Court of Appeal did it again in the United Bank of Kuwait case in Hamoud, page 1965. In our submission, my Lord Burrows.
Could I just ask 2 points in relation to your submissions here? I'm just looking at the non-disclosure agreement, the clause 1 of that agreement, which sets out the purpose of the non-disclosure agreement and includes the words, it's for the purpose of obtaining legal advice on behalf of claimants. Now, the obtaining of legal advice from Harcus Sinclair is something that a firm of solicitors would be expected to do in their capacity as solicitors.
Yes.
So aren't we here being told, well, the whole purpose of this is intimately connected, I think the judge said, with a standard role of a solicitor, which is giving legal advice?
Lord, as I say, the two answers that we have to that are, first, that isn't the right question. The purpose for which the disclosure may be being made doesn't answer the question as to the content of the non-compete clause. So if you accept our analysis, the relevant legal question for classification is the content of the non-compete clause the provision of solicitorial services? Is an agreement not to compete a solicitorial thing?
And that leads to my second question. Oh, sorry.
No, well, sorry, I don't know if this is an answer to your second question, but the second half of our answer is to sort of echo what I tried to convey already, which is that even if one were to take the approach that the judge took and say that the question is to, in a sense, sort of ascertain how close a connection there is between the undertaking and the provision of solicitorial services. In our submission, the connection is not sufficiently close. What your Lordship has identified is the purpose of the disclosure. That I can't deny. The purpose of the disclosure was expressed to be the provision of legal advice. But that doesn't, all that demonstrates is that these words in the second sentence of clause 2 appear in a contract that happens to be dealing with that. But it is a mere non-disclosure agreement. It is not a contract for the provision of legal advice. As I say, the non-compete clause is simply bolted into that, and it doesn't, in our submission, have a relevant connection with it, even if the judge's test is the right one to adopt. I don't think I can go further than that.
Can I then? I mean, my second question is closely linked to that. Are you saying the same about the the rest of this non-disclosure agreement? So the obligation not to disclose the confidential information, is that also not a solicitor's undertaking on your submission?
We haven't taken a position on that, and I'm not sure we would need to. And I'd certainly like to think about that. It's not.
I mean, the reason why I ask is that it might be said against you that if the non-disclosure part of this non-disclosure agreement is a solicitor's undertaking, it might be odd to then hive off just the non-compete part of it as not being a solicitor's undertaking.
Well, I would certainly wish to take issue with that, my lord, because as the Court of Appeal themselves said, Clause 2 is dealing with, I think this is in paragraph 86 of the Court of Appeal judgment. Clause 2 is dealing with two entirely separate things. One is non-disclosure, and the other is non-competition. They are entirely discrete. The Court of Appeal was saying that precisely because on one of the issues that's not in front of you, which is the interpretation of the clause, those then representing Harcus Sinclair were urging on the courts below an interpretation that the non-compete related only to non-competition based on the confidential information that was going to be provided. And the Court of Appeal said, no, that clause 2 is dealing with two entirely distinct questions. The non-compete can't be sort of fed into or qualified by the confidential information element. So we would suggest that the non-compete clause is entirely distinct from the non-disclosure element.
So your submission is that the rest of this clause may perfectly well be a solicitor's undertaking.
I'm very happy to submit that, my lord. Yes, even if it were a solicitor, even if the first half of clause 2 were a solicitor's undertaking, that does not lead to the conclusion that the second sentence is. And if one just steps back, the last thing I was going to say, I want to finish with this as quickly as I can because there's much more to do. The last thing we were going to say in relation to this is if one simply steps back, as the Chancellor did, as you've seen us quote his words at the beginning of our case, if one steps back and simply applies the judicial experience test to this, is a non-compete clause anything remotely like anything that has ever been held to be a solicitor's undertaking? And it is difficult to convey the surprise on behalf, certainly of my clients, that this should be regarded as a solicitor's undertaking. It's a business deal. Solicitor's undertakings are about holding monies, lodging documents at court, completing transactions. This is a business compete clause between rival firms. And as we say, and we've quoted it, it's pages 2414 and 2422 in the bundle. We've got the transcripts of where the then Chancellor dealt with this point in the course of argument. And it spills over into another point, which is a matter of policy. This, as you know, this litigation is a dispute between firms of solicitors acting in their capacity as competitors. Why should the court be looking for a role in exercising a supervisory jurisdiction over solicitors in relation to a competitor's dispute? If the court were to extend its jurisdiction in this way, it would be exercising it simply because Harcus Sinclair is a firm, an LLP, comprising solicitors. And that isn't the right test. An agreement made by somebody who happens to be a solicitor is not, for that reason, a solicitor's undertaking. And there is no need for the court to exercise this jurisdiction in this situation, as again, as Geoffrey Voss pointed out, contract law provides the answer or it doesn't. Either the undertaking meant what your lawyers say it means, in which case they have a claim in contract, or it doesn't. If there has been some regulatory breach, the regulator can be brought in. But there is no need for the court to be exercising a supervisory jurisdiction, and one just needs to recall the repeated statements in the case law that this is a jurisdiction to be exercised in clear cases in order to save a client, for example, the paradigm case, the need to bring separate proceedings in order to get a solicitor to do what he has agreed to do. The whole course of this litigation, with disclosure, pleadings, witness statements, cross-examination, and days of trial, demonstrate that this is not the kind of dispute that should lend itself to the supervisory jurisdiction of the court. So, as I say, simply stepping back from the case law and the detail, we would invite you to take collectively the response that the then Chancellor took arguendo, and just say, no, this just isn't the kind of thing that should be classed as a solicitor's undertaking. Very finally, some mention has been made of the current definition of undertaking in the current regulatory definition. If you want to look at that, I'm not going to take you to it, but it appears, I think, twice in the authorities bundle. We've got it at page 493 and at page 500. It has broadened since the definition that we saw in the first instance judgment. And that, in our submission, tells you two things, because first of all, it tells you that it is plainly not a definition that purports to be based on the case law defining the court's inherent jurisdiction. Because the case law hasn't changed the definition of a solicitor's undertaking, the regulator has. So what that tells you is that the SRA definition is a regulator's definition. It doesn't purport to be a codification of the scope of the court's inherent jurisdiction. So we would invite you to put that, the current definition, to one side and simply address the case law. And for the reasons that we've offered, we would suggest that the judge at first instance got that issue 1 wrong. If I could then move on. Issue 2 in the appeal is if, in principle, the court's inherent supervisory jurisdiction is engaged in relation to the restriction in clause 2 of the NDA. The question is that jurisdiction available as against Harcus Sinclair LLP? Now, there's quite a lot to be said in relation to this, but in our submission, the answer is it is quite simple. I just want to move through it relatively rapidly, but there's a certain amount of ground to cover. The first point we just wanted to make is this: my learned friend's written case and his oral presentation dwelt for some time on the scope of the court's inherent jurisdiction generally. That is to say, its inherent jurisdiction that derives from its status as a court. And that is the jurisdiction, for example, to prevent abuse of process and to deal with contempt of court. Now, that, as we submit, is an irrelevance in this context. It happens to have the same words in its title, so to speak, of inherent jurisdiction, but it tells you nothing about the scope of the court's supervisory jurisdiction in relation to solicitors. And the reason is simply that the court's general inherent jurisdiction to manage its own business is a function of its status as a court. And as a result, it is exercisable in relation to any court users. It's exercisable in relation to litigants who commit abuse of process or contempt of court. It's exercisable against witnesses. It's exercisable against barristers who are not officers of the court. It's exercisable in relation to mere members of the public if they attend court and commit a contempt, as very occasionally happens. So it is a jurisdiction which is exercisable, first of all, simply as a result of the status of the court as a court. And secondly, it is exercisable in relation to users of the court, whether they are spectators, lay clients, or professionals, or witnesses. So none of that tells you anything of value about the scope of the inherent jurisdiction of the court to supervise solicitors. The only thing you get from the historic review, and the one important point, is that the juridical basis for the exercise of the court's supervisory jurisdiction over solicitors derives from the fact that solicitors are officers of the court. And that, in fact, if I can just give you some references, it is acknowledged in my learned friend's own case at paragraph 51 that that is the basis of the court's supervisory jurisdiction over solicitors. It's because they are officers of the court. Paragraph 51 of his case, and we give more flesh to that in paragraph 33 of our case. I'm not going to take you to them, but just to give you a little handful of references, it's covered in Holdsworth's History of English Law at page 2232. It's also touched on, for what it's worth, in Myers and Ellman at page 1410. And if you want, in a sense, the most pertinent one-liner from the case law, in the John Fox case, the court described it as a jurisdiction to which solicitors are only amenable because of their special relationship with the court. That's in the bundle at page 1080 at letter F. So that's all we seek to get from the historic review, that is the origin of the jurisdiction to supervise the conduct of solicitors. They were, as we've said in our case, they were admitted to practice in the courts in which they wished to practice by the courts. And it was through that route that the courts exercised the supervisory jurisdiction over them. Now, if we move on and look at the current regulatory regime, we would just wish to emphasize 3 points. The first is that the Law Society now has an express statutory power to make rules regulating the professional conduct not just of solicitors, but of the authorized bodies which can now provide legal services. So there is an express statutory regime, first of all, which allows authorized bodies to deliver legal services, and second, makes provision for a regulatory regime for those bodies. And one gets that. I think the relevant legislative material has been mentioned in our case, but just to put it in context, that's the Solicitors Act 1974, section 31, which is at page 428 of the bundle. It's the Administration of Justice Act 1985, section 92F, which is page 348 of the bundle. And it's the Legal Services Act 2007, section 83(5)(c), which is at page 400 of the bundle. So we can just leave that. I will tie these points into our submissions in a moment. But if I could just leave that thought with you first. Express statutory regime for the regulation of these new legal entities. Second point, under the new regime, your lawyers accepts, as it must, that only a natural person may be admitted as a solicitor, and a body corporate cannot be. That's paragraph 37 of my learned friend's case. And my third point requires us to look at the Solicitors Act, 1974, section 50. If we could go, that's at page 436 of the bundle. If we could look at that. Section 50, subsection 1, tells us that any person, and we know that that means natural person, that's common ground, duly admitted as a solicitor shall be an officer of the senior courts. Subsection 2, subject to the provisions of this Act, the High Court, the Crown Court, and the Court of Appeal respectively, or any division or judge of those courts, may exercise the same jurisdiction in respect of solicitors as any one of the superior courts of law or equity from which the senior courts were constituted might have exercised immediately before the passing of the Supreme Court of Judicature Act 1873 in respect of any solicitor, attorney, proctor. So the inherent supervisory jurisdiction which has been preserved in the context of all the legislative developments that we have seen, the supervisory jurisdiction that has been preserved is a supervisory jurisdiction in respect of solicitors. Can I just finish this? The closing point, my lady, is that by definition, Harcus Sinclair LLP isn't a solicitor. So in order to persuade this court that the High Court has a supervisory jurisdiction over Harcus Sinclair LLP, my learned friend has to persuade you that there is an inherent supervisory jurisdiction other than that preserved by Section 50 of the Solicitors Act. And there is, with the greatest respect, absolutely no source or justification for that proposition. And the point is that simple. Whether one wishes to come to that conclusion or not, that is, without doubt in our submission, the position that has been left by the legislation. A lot of my learned friend's argument was directed towards attempting to show that if this is the outcome, there is some sort of lacuna and it's all very regrettable. But with the greatest respect, that is no argument at all. Because if there is a lacuna, which is frankly in the eye of the beholder, given the existence of the regulatory regime, if there is a lacuna, it is the result of primary legislation, not extending the court's supervisory jurisdiction to LLPs, limited companies, alternative business structures, and so on. The source of the lacuna, if it's a lacuna, is the primary legislation. If there is to be a solution to that lacuna, it has to be a legislative one. Because if the court, with respect, starts flexing its supervisory muscle in this territory, one immediately gets into awful regulatory mismatch. Because the question then arises, well, is it being suggested, and I think this question was put to my learned friend, if the supervisory jurisdiction can be exercised against bodies that happen to contain solicitors, what happens in relation to an alternative business structure which may have accountants or barristers as members, managers, or indeed private equity owners? Are they subject to the jurisdiction? And if they're not, then it is an extremely elastic jurisdiction as to its application. Because if it is exercisable in relation to an LLP which happens to contain solicitors and nothing but, but it isn't exercisable in relation to an alternative business structure, even if the undertaking is given by a member of it who happens to be a solicitor, then all Malone and Friends' argument has produced is to shift the nature of the lacuna. My Lady Arden, sorry, you had a question about 5 minutes ago, but I just wanted to finish that run.
Of course, I well understand. You have danced around this point, but could I just try and make it a little bit more precise? You use the words preserved and that Parliament has not extended the inherent jurisdiction. Is it your submission that Section 50, subsection 2, and its predecessors, if any, have consolidated and codified the inherent jurisdiction, so that this is now what we must take to be an exclusive statement of it?
Yes.
There was a second question before you answer that, and maybe you want to give reasons to add to your answer just now. If I could just do it while I'm, as it were, holding the floor, and it's simply this: could you just tell me whether or not there has been a change in practice? And I mean, you may want to take some instructions about this, whether solicitors are now, when they're dealing with LLPs, ensuring that they take the undertaking from individual solicitors with practicing certificates.
Well, my instructing solicitors did do some research, because I think this point was raised yesterday, and we're very grateful. The answer is obviously the solicitor profession is a large one. There isn't a sort of single coordinated direction of travel. But the one thing that was discovered overnight, and we can certainly provide copies if this would be of assistance, that there are various, not quite sort of chat forums, but there are legal platforms on which issues are discussed. And we certainly have found the decision in this case being discussed, and solicitor saying, look, I've been asked, I'm working for an LLP, I've been asked personally to give an undertaking rather than for the LLP to give an undertaking. What do you say about this? And answers come back saying, well, that's a difficult one. We better, it sounds like one for the SRA. So I think the answer to your question, I mean, that is anecdotal. I entirely accept. I don't think one could come up with anything more overnight than anecdotes. But I think the answer is yes, clearly the profession is alive to the existence of this judgment. And the judge at first instance indeed expressed his own views as to the importance of the profession being aware of this. And so the answer to your question there is, has a practice developed? I don't know. It presumably depends upon how up to speed solicitors are in relation to this. I think some will be and some not.
Okay, because it derives really from Canad. That's very helpful. But on the first point, about codification of the inherent jurisdiction?
Well, it is in the context of the preservation of what had previously been a jurisdiction exercisable by lots of different courts. Section 50 of the 1974 Act is the successor to something that has been on the statute book in the same form since I think the 1873 Act. And so our submission is that yes, it is a codification of the inherent supervisory jurisdiction, because it was gathering together jurisdiction that was hitherto exercisable in relation to a number of different kinds of legal practitioner, solicitors, attorneys, and proctors. And so in our submission, it is both preserving and codifying, and therefore delimiting the jurisdiction.
Thank you. Is it possible? I'm sorry.
Sorry.
I just want to say, if you mentioned the 1873 Act, could you dig out the section for us?
Yes, if it's not in our case, I'll be reminded. Can I come back to you on that later?
Of course, thank you.
Mr. Crowe, I think Lord Briggs has
Yes.
an issue that he wants to raise with you, which I think is a matter that a number of us want to raise.
Mr. Crowe, you'll no doubt be aware that the similar sort of questions that we've just been discussing in relation to Section 50 of the Solicitors Act have arisen in relation to Parliament's recognition, for example, of the court's power to grant injunctions, and whether it then sets itself in aspic at that stage or is capable of further development. Just within that general context, I think we are anxious to look at this, what the judge described as curious anomaly, from all possible angles and directions. And I want to put to you this not as any kind of concluded view, but as an argument on which I would like your submissions. The Act recognises, as I think you first said, an inherent jurisdiction. Over the centuries, that inherent jurisdiction had come to be applied by the courts without any assistance from Parliament to differently named types of or classes of people, admittedly at that stage all individuals, who had really on a functional basis that they were providing, I think originally in court, although it's obviously extended beyond court, certain types of services which the court ought to regulate. By the time we got to the modern reforms of the legal services market, that court jurisdiction had come to extend to everything being done by solicitors. In other words, looking at it in functional terms, to the whole of solicitorial services, whether they had anything to do with the court or not, such as undertakings being given in day-to-day conveyancing situations. When Parliament saw fit to introduce for the first time corporate bodies to perform what in the legislation are actually called, I think, solicitor services, I appreciate there are two stages, there are solicitor services and there are more general legal services, but they're dealt with distinctly in the legislation. But confine ourselves for the moment to solicitor services. Why was not the continuing recognised inherent jurisdiction capable on a functional basis of extending itself to those new classes of person, incidentally for the first time corporate persons, authorised by Parliament to hold themselves out to offer and conduct solicitor services?
Lord,
I raise it with you in that rather long way because it's not quite the same submission as we got yesterday from Mr. Coleman, but it's one which I at least would hope you would deal with.
Thank you.
Maybe you're going to anyway.
Well, to some extent, I've approached the foothills of that by the submission, first of all, as to the nature of the origin of the jurisdiction. The origin of the jurisdiction is in the special relationship between the court and the solicitor. And it is founded, and the case law repeatedly says this, it is founded on the fact that solicitors are officers of the court. Now, by definition, a legal person isn't a solicitor and isn't an officer of the court. So the answer to your lordship's question is to be found in divining the legislative intent in permitting these new entities to deliver legal services, granting to the Law Society the power to make regulations regulating the conduct of the entities, and not amending Section 50 of the Solicitors Act so as to provide that the court's jurisdiction extends to solicitors. And one answers the question as to what is the end product, so to speak, with one eye on that list we've given in our written case of other illustrations where new things come into existence under largely insolvency law, where the court has, where Parliament has expressly provided that they should be officers of the court and that the court's supervisory jurisdiction as a result extends to them. Now, that combination of factors in our submission leads to the conclusion that it is not Parliament's intention that the supervisory jurisdiction should be available in relation to these legal entities. Does it answer the question from the court's point of view, if you're asking, is it inconceivable that the court should choose to exercise a jurisdiction in this way, that is a question only the court can answer, and I can't answer it for you. But given the, as I say, the juridical source of the jurisdiction over solicitors being their status as officers of the court, and given the legislative context, in our submission, it would be a wrong road to go down. The way my learned friend puts it, and I think that you're right, he doesn't put it exactly like this, but in paragraph 55 of his case, he says that this is a well-established jurisdiction, and that it's one that, I think in the course of his oral argument, he said it was one that has to be exercised by a reference to law and conscience, not by reference to technical rules. If I can sort of try and capture our response to that, our submission essentially is that a jurisdiction doesn't exist in the abstract. A jurisdiction exists in relation to a particular class of person. And if a jurisdiction exists in relation to a particular class of person, yes, it will, as in re Bailey, which I think is what my learned friend was quoting from, if it exists as a jurisdiction in relation to a particular class of person, it can be exercised by reference to law and conscience in the sense that the court can choose to exercise or not exercise the power it undoubtedly has. But it is a false argument in our submission to argue from that the jurisdiction can be extended so that it is exercisable against a category of person against whom it has never been exercised. And in our submission, the answer is essentially to be found in very clearly and very shortly stated in the Asabayev case. We needn't go back to it, but the short and relevant paragraphs of 46 to 49. And in our submission, it would be inconsistent for the reasons the Court of Appeal gave there. It would be inconsistent with the current statutory regulatory regime for the court now to decide that it does have a supervisory jurisdiction over legal persons as well as over officers of the court. And it would lead to the regulatory mismatch that I've described, because it would lead to the conclusion that the supervisory jurisdiction can be exercised over an alternative business structure, which isn't entirely made up of or owned by lawyers. And in our submission, the only way of solving that risk would be to say, yes, well, it is in principle exercisable against ABSs, but the court wouldn't do that. In our submission, that is simply, yes, my lord. I think you're mute.
Is a possible answer to that question is that it would be extended only to the extent that that legal person was providing solicitor services. In other words, was doing what prior to these reforms only solicitors did. In other words, it will be extended on a functional basis to those functions of the alternative business structure that were providing solicitor services, which seems to be a concept clearly recognised by the legislation.
My lord, the very fact that we're having this discussion at this sort of level of detail, so to speak, in our submission demonstrates that this is not a question that can properly be answered by judicial will.
Well, that's kind of point. Just before you go on, was that not how it was answered when it moved from attorneys to proctors and proctors to solicitors?
No, because they were admitted by the courts in which they were appearing.
Yeah, yeah.
So the very fact that you could come up with a number of different solutions to the regulatory mismatch problem in our submission demonstrates that the point I was making earlier, which is that if it is to be regarded as a lacuna in the regime, It's a lacuna that results from legislation, and the policy answer to it is so fraught with potential difficulties and is so open to different potential solutions that that just demonstrates that the solution has got to be a legislative one, not judicial, because you would simply be legislating. If you designed a jurisdiction that is exercisable in this kind of case, not exercisable in this kind of case, depending on this, that, and the other, you are effectively legislating. And the other point, as I say, is in presenting the argument, I said that my learned friend's objection is based on the assertion that there is a lacuna here. That is assuming quite a lot, because Parliament has put in place this new regime for legal entities to provide legal services, and it has chosen not to extend the supervisory jurisdiction currently embodied in Section 50, subsection 2. Now, on an entirely orthodox approach to statutory interpretation and the divining Parliament's intention, our submission is that there isn't a regulatory lacuna as a result of some oversight. There is a positive legislative choice. The positive legislative choice has been expressed in permitting legal entities now to provide legal services, but not to amend Section 50, subsection 2. So for the court to assume to itself a jurisdiction which has never previously exercised in relation to legal entities in that context, in our submission, would risk intruding into a field which is occupied by legislation.
I mean, I quite understand the way you put it as legislation. We're oddly enough dealing with a case in which there are at least 2 cases at High Court level where the court did in fact do so against an LLP without turning a hair. One is the one mentioned in the bundles, a decision of Miss Asplin, Queen's Counsel as she then was, and the other one I think is Marine Drill Ships in La Bella in 2014, decision of Mr. Justice Newey as he then was. So that you have a situation where these legislative changes are made. The High Court has apparently thought it really too obvious to need to mention, obviously in the absence of any argument to the contrary, I agree, that since the services in question about which complaint were made were solicitor services, they should be subject to the High Court's regulation. And now, of course, we have a decision to the contrary, which is why one of the reasons why we're hearing this appeal.
Indeed. Well, my lord, if I could respond to that, your lordship says there are 2 decisions where the High Court exercised a jurisdiction without turning a hair. It exercised that jurisdiction without turning its mind to the question with respect. And to suggest that the reason why it did that was that it saw nothing wrong assumes that the court saw that there was a potential problem, but chose that the answer was so clear that not only could it be done, but it could be done without commenting on it. So, my lord, with the greatest respect, when we are having an argument of principle in the Supreme Court, for your lordship to suggest that your decision should be influenced by unreasoned assumptions made at first instance in our submission would be the wrong approach. As I say, the position we suggest you get to is that where Parliament has chosen to put in place a regime under which there is a regulator who is empowered to make regulations and to enforce regulations for the professional conduct of these new entities, and where Parliament has not extended the power in Section 50, subsection 2, it would be wrong for the court, nevertheless, to say that the inherent jurisdiction can now occupy essentially the same territory.
Thank you.
I think that is all that we wished to say in relation to issue 2. Issue 3 I'm just about to start a new topic. It's not 1:45 yet, but would it be convenient, my lord, to have a break 10 minutes early rather than starting a new topic?
If that's convenient for you, Mr. Crowe, certainly. We'll stop now.
Thank you.
5-minute break. Thank you. Yes, Mr. Crowe.
Thank you, my lord. Can I just pick up 2 points before moving to the next issue? My Lady Arden asked for reference to the legislative antecedents of the 1974 Solicitors Act, Section 50. They're summarised in our case at paragraph 41, and the first one, the 1873 Act, is in the authorities bundle. It's page 445. The other thing I should just have touched on is the case law that is mentioned in my learned friend's written case, which he says illustrate the court's exercise of a jurisdiction against people who are not solicitors. My Lord Lloyd Jones suggested that one of those can be explained on the basis of an estoppel. I anticipate from the fact that your lordship made that intervention that you're all familiar with the cases. The three that are mentioned in my learned friend's case is Symes and Gibbs. I don't ask you to go to these now, but that's at page 1823. That was a case dealing with a situation where an attorney had given had undertaken an obligation while he was an attorney. As it happens, it came to be enforced after he had ceased being an attorney, and the court said that didn't make any difference. So with respect, that doesn't take the principle very far. The second case was Hume and Lewis, which is page 1284. That was a case in which somebody had obtained money and property while purporting to act as a solicitor, and an order was made against him on that basis. The order was made on the basis he was a solicitor. It was only when an application, because he failed to comply with the order, and an application was made for attachment, he took the point he wasn't a solicitor, and the court didn't have jurisdiction to make the order in the first place. But that was an argument that was raised after the relevant order had already been made on the basis that he was a solicitor. As my Lord Lloyd Jones pointed out, in the subsequent case of Hurst and Middleton, Hume and Lewis was analysed as being one based on estoppel, namely that the order having been made against a person on the basis he was a solicitor without him disputing that fact, he couldn't then subsequently, in order to avoid compliance with it, say, I'm not a solicitor. And the third case, that one just mentioned, Hurst and Middleton, which is page 1292, was a case in which the court did not exercise a supervisory jurisdiction because the person was not a solicitor. That is all I wanted to say on issue 2. If we can move on to issue 3, which is the question whether, assuming the supervisory jurisdiction in principle applies to this restriction, does it apply to Mr. Parker personally? And again, I can move through the points relatively rapidly. Starting simply with the position under contract, there's no dispute. The position in contract is not in doubt. Mr. Parker signed the non-disclosure agreement as the agent of a disclosed principal, and he assumed no contractual liability personally. That is conceded in my learned friend's written case at paragraph 77, and it has not been argued otherwise. I think my Lord Burrows asked yesterday whether any point had been taken that even as agent, Mr. Parker might be personally liable. And the answer is that has never formed part of your lawyer's case. And your lordships can see that, your ladyship will see that from paragraph 25 of the first instance judgment, where the judge there records the fact that it was not contested, that Mr. Parker was not personally contractually liable. Paragraph 25 of the first instance judgment, which is page 218 of the bundle. So the question, that being the contractual position, the question in the appeal is whether the court has an inherent supervisory jurisdiction to enforce an undertaking against a person who is not contractually bound by it. And our answers can be grouped, I think, under 5 short headings. The first can be labelled for short, legal certainty. We've seen from the case law we've already been through that the court has emphasised more than once that the inherent supervisory jurisdiction should only be exercised in clear cases. You get that from the Silver and Drake and Baines case at page 1094 at B, and it's repeated in the John Fox case at 1080H. Clarity must mean both clarity as to the existence and meaning of the putative undertaking, and also as to the identity of the person bound by it. So where a legal entity gives an undertaking, only the legal entity should be treated by the court as being bound by that undertaking, not the individual who happens to sign the document. Because if one starts extending the jurisdiction to persons who are not the persons giving the undertaking, you are creating an area of uncertainty. And you are doing that in circumstances where the consequences are potentially penal. There are a number of the cases you will have seen discuss the slightly procedural question, whether the court can order committal immediately against a solicitor for non-compliance with an undertaking, or whether the court should, as a matter of practice, order him to comply with the undertaking first and then commit him if he doesn't. Now, that is an interesting procedural argument which doesn't arise in this case, but the very fact that the consequences, or at least the potential consequences of non-compliance with a solicitor's undertaking are penal, militate, when one's thinking in terms of the need for clarity, they militate very strongly in favour of not exercising a supervisory jurisdiction over a person who didn't give the undertaking. So that's the first heading that we would submit. The second heading I can call regulatory mismatch, and it overlaps with some points that have already been made in relation to issue 2. The court's inherent supervisory jurisdiction, by definition, is not itself a creature of statute, whereas the modern regulatory regime has, through statute, enabled legal persons to deliver legal services. That being the position, in our submission, one should be looking to the legislative regime for the reach of the regulatory grip over the legal entities, and not adopting a sort of ad hoc elastic approach by extending the court's jurisdiction to persons who themselves did not give the undertakings. The third heading is case law, authority. Now, this point has never itself arisen directly for decision, but there have been a number of cases in which the courts have had to grapple with a cognate issue involving who else, other than the person signing the bit of paper, should be held liable for a solicitor's undertaking. And that question, who else, has arisen either in factual situations where somebody who isn't a solicitor has signed the undertaking, a clerk or a managing agent or whatever, or in situations where a partner, a solicitor, has, and the question is whether the other partners have. In those contexts, as the judge at first instance accepted, the analysis that's been adopted has been the agency approach. And one sees that both in the Silver and Drake and Baines case. One sees that at page 1093, B to C, and 1095D. And one sees it in the Hamoud case, United Bank of Kuwait and Hamoud, at pages 1971, F, 1977, C, and 1979, B. We obviously can't place too much reliance on that. I'm not suggesting the point has been decided, because the point that you're grappling with hasn't arisen. But as I say, in relation to cognate issues, where the question, who else other than the person whose signature is on the page should be liable, the approach that has been taken has been the agency analysis. And if you take that approach in this case, Mr. Parker personally isn't contractually liable, and for that reason, we would submit it would be wrong to extend the supervisory jurisdiction to him. The fourth heading, we would just group under the label of practicalities. And to an extent, this has been touched on in the course of oral argument yesterday, when my learned friend, I think, was being asked, well, what happens if somebody moves from one firm to another? What happens if the person signing the piece of paper is, in fact, for whatever reason, not in a position to procure the firm to do what, as a matter of regulation, my learned friend would wish? So one has practical difficulties, inevitably, in any situation where you are trying to visit responsibility on a person who isn't the person who undertook the obligation. And the final heading, the fifth heading, is a point of sort of principle or possibly of separation of powers. And it arises in this way: because limited liability legal entities are now able to deliver legal services, if the court's supervisory jurisdiction is said to be exercisable against an individual who is a member or director of a legal entity which has given the undertaking, then one is, with greatest respect, undercutting the regime which Parliament has put in place. Because if Parliament has said it is now acceptable for an entity with a limited liability to deliver legal services, if the courts then say, yes, but we're going to exercise the supervisory jurisdiction against an individual, as we know, one of the tools in the court's armory of supervisory jurisdiction is not just to tell solicitors to do what they've said they would do, but to award compensation. So if the jurisdiction is said to be exercisable against an individual where the legal person that gave the undertaking is in fact a limited liability entity, the court would, with the greatest respect, again be undercutting, as we say, the new legislative regime, and that is wrong in principle. Again, my learned friend might seek to say, oh, well, you can sort of solve that kind of problem by simply choosing not to exercise the jurisdiction so as to impose on the individual a liability for compensation greater than X. But the very fact that the jurisdiction immediately has to be trimmed, so to speak, in order to fit neatly within the new legislative regime, illustrates in our submission that it is simply not the right vehicle to be driven onto this lawn. So we submit, for those reasons, the supervisory jurisdiction, if in principle it is available, is not one that can be exercised against Mr. Parker personally. And in that respect, the judge at first instance was entirely correct. I think Lord Burrows beat you to it.
It may be that you don't feel in a position to help with this, but I would find it helpful to know in what situations a solicitor who is part of an LLP could make themselves liable on a solicitor's undertaking. What I've got in mind is if Mr. Parker here had signed in my personal capacity and on behalf of, or something to those words to that effect, I'm rather assuming that there would then be a liability to him, even if not to the LLP. Would you be able to assist on that?
Well, my instinctive reaction is absolutely to agree with your lordship, and that seems to have been the issue that we have identified being discussed in I think practical law online. Presumably, if a solicitor does personally sign something on his own behalf or her own behalf, then that is a personal undertaking by that solicitor, and that may be the sensible tool in practice for those who wish to benefit from solicitor undertakings where they are dealing with limited companies or LLPs. My Lord Briggs.
Mr. Craig, can I just test your submission? I'm not here concerned with the fact that the solicitor signed the document by which the LLP gave the undertaking, but with a situation where the solicitor is instrumental in the LLP breaking it. Suppose it was an undertaking of a solicitorial type, taking your negative example yesterday, not to act for a particular person where arguably it would involve a conflict. And it was given on behalf of the LLP, and the LLP was a, let's say, two-solicitor LLP with two members, and one or other or both of them proposed to do precisely that which their LLP had promised not to do, and they were both solicitors. Would the court really be powerless to do anything about that?
Not necessarily, my lord, but that doesn't prove anything about the inherent supervisory jurisdiction.
Well, I mean, I'm sorry, I mean under its inherent supervisory jurisdiction.
Well, but that's not the only weapon. If there has been a contractual commitment, contract provides the solution. If there is a regulatory breach, there is a regulator that can provide a solution, or at least a consequence.
But can any regulator grant an injunction? Can any regulator grant an injunction? Say it was something they were threatening to do on a Monday, and the client to whom the undertaking had been given by the LLP on the Friday finds out about it on the Friday. There's no way a regulator could stop them doing it. But
if an agreement has been made, there's no reason why it can't be enforced in contracts and injunction obtained on that basis. One doesn't have to struggle to find a supervisory jurisdiction.
Suppose it was non-contractual.
I can't imagine why it wouldn't be, but I mean, the fact that one might hypothetically come up with situations doesn't, with respect, answer the point of principle by reference to the arguments we've advanced.
Yeah.
And if, again, it really comes back to a point we made in relation to issue 2, which is that if it is thought that there might be some sort of lacuna, the origin of the problem, if it's regarded as a problem, is in the primary legislation. And because there are so many different possible solutions, the policy choices as to which the right solution should be isn't a matter the court can just take. In earlier and simpler times, where solicitors were the only things that could practice and they were officers of the court, you get a very simple solution. But in the world that has now been created, there are so many different ways of skinning the cat that it would, in our submission, be problematic for the court to simply make some policy decisions in the face of the existing legislative regime. So whilst it is, I suppose, possible to conceptualize of hypothetical situations which might produce unfortunate results if such a situation as your lordship posited could exist with no contractual remedy, it is possible that an unfortunate outcome might exist in some hypothetical case.
Okay, thank you.
Issue 4. Issue 4 is still looking at the inherent supervisory jurisdiction. And the question that is asked here is, assuming the restriction is an unreasonable restraint of trade, should that impact on the court's willingness to exercise its supervisory jurisdiction? So to some extent, we are grappling here with the question of whether or not what might be called contractual defences are relevant in resisting enforcement of an undertaking through the exercise of the court's inherent supervisory jurisdiction. Now, my learned friend conceded in the course of his oral argument, as he must, that contractual defences are relevant. They are taken into account by the court in exercising its inherent supervisory jurisdiction. There is no blanket rule that no contractual defences are ever available. So if that is the situation, and I say he conceded as he must, that is, for example, what is said in Udall and Capri Lighting. Just to give you the reference, it's page 1957 at G. The court does not ignore even standard contractual defences when it is exercising the supervisory jurisdiction. So if that's the starting point, the second stage in the analysis we would submit is this, that plainly the question whether to enforce or not enforce a solicitor's undertaking in exercising the court's inherent supervisory jurisdiction is a matter of judgment, discretion, which involves a balancing exercise between competing interests. And just to go to one case to illustrate this, again, quite an ancient one, but none the worse for that. We look at Sedgeworth and Spicer, which is at page 1791. The facts may seem slightly arcane now, but I think it came from the days where sheriffs might make a bit of a living out of being paid to release people. The facts were that the defendant in proceedings had been arrested by the sheriff, and the defendant's attorney undertook to the sheriff to give a bail bond in due time, and on that assurance, the sheriff released the defendant, but the attorney then failed to produce the bail bond. The plaintiff in the proceedings sued the sheriff for the escape and recovered against the sheriff. So the sheriff then took proceedings against the attorney who had failed to produce the bail bond. And so essentially the question was whether or not the attorney who had undertaken to provide that bond should be held to it. And if you see at page 1792, essentially, what the court is saying is that there is a statutory definition of the circumstances in which sheriffs are entitled to release. The bond in this case didn't comply with that requirement, and therefore it's invalid under the statute. And so we're not going to enforce it, even though it is in fact a solicitor's undertaking. So what that illustrates is that a competing public policy, namely in that situation, the correct form for a bond in order to discourage sheriffs from extorting, a competing public policy is capable of overriding the public policy in favour of enforcing solicitors' undertakings. And one sees, in a sense, most clearly from the last few lines of Mr. Justice Lawrence's ruling, it is fit that the defendant's attorney should understand that it is only for the sake of the public and to prevent a practice which leads to extortion that we would refuse to listen to an application against one who has acted so dishonest a part and shown himself so little trustworthy. So the solicitor in that case, the attorney in that case, was regarded by the court as having been dishonest and untrustworthy, and had failed to perform his undertaking to the sheriff. But there was a countervailing public interest in upholding the form, the necessary form, for bail bonds. And we have identified in our written case, I'm not going to go to each of them, but we have identified other situations where solicitors' undertakings have not been enforced, or their enforceability has been considered against other public policies. Now, if I just mention them and explain them without going to them, because we need to move on. Rooks, Ryder and Steele, which is page 1765, was a case ultimately in which the solicitor's undertaking was enforced, but the question that was being examined was whether the solicitor was on notice of his own client's illegality. And if the solicitor had been on notice of his own client's illegality, it is quite apparent from the reasoning in that case that the undertaking would not have been enforced. Taylor and Ribby Hall is at page 1882. That was a case in which a claim to enforce a solicitor's undertaking was struck out for inordinate delay. Now, again, the facts are very different, but the underlying principle is clear and very important, which is that the public interest in litigation being pursued expeditiously is a public interest. And in that case, it was held sufficiently important to overbalance, to outweigh the public interest in enforcing a solicitor's undertaking. And the final case is a collision in the Thames, a case called the Boar, page 683. It's worth looking at that. I'm not going to take you to it. It's worth just following the facts in that case carefully, because what is quite clear is that the principle in that case was that the enforcement of a solicitor's undertaking could be outweighed in circumstances where there had been waiver, if waiver were established. So what one gets, my lord, my lady and my lords, the facts of these cases are all obviously significantly different. But the underlying point is simply this, that the status of an undertaking as a solicitor's undertaking is not a magic wand that wishes away all forms of defence. There plainly are situations where contractual defences or defences based on public policy have been held sufficient to justify non-enforcement of a solicitor's undertaking. And what one takes forward from that is our next point, which is that restraint of trade plainly isn't a common or garden contractual defence. It is a matter of public policy. And so, bearing in mind that it is the case that mere contractual defences are relevant in the court's decision whether or not to enforce a solicitor's undertaking, the fact, assuming it is a fact, that this restriction is an unreasonable restraint of trade is an expression of a public policy. It's not just a sort of private interest, contractual defence. It is an expression of a public policy. And for that reason, in our submission, it has a powerful claim to outweigh the public interest in support of enforcing the solicitor's undertakings. And that very much meshes in with the next point we were going to make, which is that the restraint of trade, we've already seen that the enforcement or non-enforcement of a solicitor's undertaking is a matter of balance, judgment, different public policy considerations. As you're already aware, the operation of the restraint of trade doctrine itself has inherent in it a balancing of interests, because on the one hand, there is the interest in parties being held to their bargains, and on the other, there is the interest in parties being able to trade freely, and the interest in potential customers or clients being able to choose whom they do business with. So the fact that the restraint of trade doctrine, in order to reach the conclusion that something is an unreasonable restraint of trade, involves a balancing exercise in itself. In the case of a solicitor's undertaking, one can quite see that both sides of the balancing under restraint of trade will have extra elements added, but the fact that it is a restraint on a solicitor's practice rather than a tradesman's practice isn't going to produce a different outcome. In the case of a solicitor's undertaking, it may be said that an extra weight should be put on the side of the scales in favour of holding solicitors to their bargains. But on the other side of the scales, self-evidently, there is the importance in relation to a covenant such as this of preserving client choice, because it is potential claimants in the emissions litigation who are ultimately the parties affected most by this. There is client choice, and there is competition in the provision of legal services. It is an important fact to remind ourselves that the whole point underlying the new regime, particularly under the Legal Services Act 2007, was that the legislator took the view that there was insufficient competition in the delivery of legal services in circumstances where only firms of solicitors were delivering. And that is the policy reason underlying the permission that has been created to have alternative business structures. It was designed to increase competition in the provision of legal services. And it's an important point that competition in the provision of legal services is one of the regulatory objectives expressly stipulated in Section 1 of the Legal Services Act 2007 and reflected in the SRA handbook. And we have the SRA handbook if you want to look at that. I'm not suggesting we go to it now, but it's in the authorities bundle at page 483. So just tying it back to where the argument was going, if it is an express statutory regulatory objective to encourage competition in the delivery of legal services, that is a factor which has to weigh in the balance when you are conducting the balancing exercise in relation to whether or not, in relation to restraint of trade, a covenant against competition should be upheld. So ultimately where we urge the court to get to is simply to say that in deciding whether or not restraint of trade, the application of the restraint of trade doctrine leads to the conclusion that this clause is unenforceable, the court will already have taken into account the features of this case. If the answer under restraint of trade, having conducted that balancing exercise, is this is an unreasonable restraint of trade and therefore unenforceable, it would be perverse then to turn round and produce the opposite result by saying, in exercise of the court's inherent supervisory jurisdiction, which involves public policy and a balancing exercise, we're going to produce the opposite answer. And we've cited in our written case, and I don't propose to go to them, but we've cited both Patel and Mirza, and a more recent decision in Henderson and Dorset Healthcare, both of which emphasize the need for coherence and consistency in the law, particularly in relation to areas such as illegality involving questions of public policy. It would, in our submission, be objectionable for the court to produce one solution, having conducted a balancing exercise in relation to restraint of trade, and then to produce the opposite in exercise of a balancing exercise under the supervisory jurisdiction. So for those reasons, we would suggest that the answer to issue 4 is that the status of the undertaking as a solicitor's undertaking, if that's what it is, should not affect the exercise by the court of the, should not affect the application by the court of the doctrine of restraint of trade. Essentially, we submit the same answer in relation to issue 5. Issue 5 looks at a pretty similar point, but from a slightly different angle. You'll recall that the question under issue 5 proceeds on the basis that the restriction is a solicitor's undertaking, but that the court's inherent supervisory jurisdiction is not engaged. And the question raised in issue 5 is, if the court's supervisory jurisdiction is not engaged, but it is a solicitor's undertaking, should its status as a solicitor's undertaking impact on the answer to the question whether it should be enforced applying the doctrine of restraint of trade? So in a sense, it's asking exactly the same question as issue 4, but from the other angle. Issue 4 was asking, does the restraint of trade outcome impact on the exercise of the court's inherent supervisory jurisdiction? And issue 5 is asking, does the status of the undertaking as a solicitor's undertaking, if that's what it is, affect the outcome of the test in applying restraint of trade? Having said that, I think in fairness, I should point out, we put the point slightly incorrectly in paragraph 72 of our case. I don't ask you to go back to it now, but if you look at paragraph 72 of our case, I think we pose the question that arises in issue 4 on the assumed basis that the restriction is an unreasonable restraint of trade, and that's putting it slightly wrong. The question in issue 5 is, should it be treated as an unreasonable restraint of trade in light of the fact, if it is a fact, that the undertaking was a solicitor's undertaking? So we pose that point slightly incorrectly in our written case, but it doesn't affect the force of the answer that we give, which to a very large extent I have already given, which is that the application of the restraint of trade doctrine involves a process of balancing competing public interests. The fact that the trade that is being restricted is the practice of a solicitor doesn't make it any less objectionable in the public interest, applying the restraint of trade doctrine. And indeed, if one takes into account the pro-competitive regulatory objective under the Legal Services Act, there would be a perfectly good argument for saying the fact that a covenant is a covenant against competition between solicitors is actually a weightier factor in favour of the conclusion that it is an unreasonable restraint of trade in the public interest. So for those reasons, essentially, I mean, I've dealt with issue 5 pretty shortly, but essentially what we say is that there is no reason why either the considerations or the outcome in relation to issue 5 should be any different from those in relation to issue 4. Both questions are addressing the interaction between the supervisory jurisdiction and the restraint of trade doctrine. And in our submission, a coherent and consistent answer must be given. Restraint of trade provides the answer, assuming that that doctrine produces the answer which the Court of Appeal did. That then does bring us to the restraint of trade issue, issue 6. Just to state the parameters of the dispute and to state the obvious, it is common ground that the non-compete covenant is a restraint of trade. That is common ground. My learned friend quite rightly recognises that in paragraph 84 of his case. So the only question with which this court is concerned is whether the Court of Appeal was entitled to reach the conclusion that it was an unreasonable restraint of trade. In addressing that, could we consider the contract and to some extent offer a response to the unilateral contract point that we briefly debated yesterday? The contract itself, as you know, is at page 338 in the bundle. And being a short contract, I imagine that you are already sufficiently familiar with it. It expresses an intention to disclose confidential information. It reflects in clause 2 an agreement not to use that confidential information for purposes other than the purpose as defined, and in clause 3 to keep confidential information secure and not to disclose it. And in clause 4 it provides that those two undertakings, not to use the confidential information for anything other than the purpose, and to keep the information secure and not to disclose it, those two apply to all the information disclosed by the disclosure to the recipient. and you'll recall in clause 7, it continues for 6 years. Now, my learned friend put to you an analysis yesterday, and your lordship and my lady are entirely right, that the analysis that was put by my learned friend was on the basis of a unilateral contract. I described it when I said it's implied term. I was distracted by him saying that it was implicit in the contract that it produced the result for which he was advocating. But I come back to the point I made yesterday, which is that analysis, that this is a unilateral contract situation in which the document, when signed, constitutes, in a sense, no more than an offer by Harcus LLP, which may or may not be accepted by your lawyers, providing confidential information. That analysis has never previously been put as part of the argument in the case. We've done our best to think about it overnight. The most that we can say at the moment is that if we had had more notice that this was the analysis that was going to be offered, we might well have wanted to consider preparing submissions at trial, let alone in the Supreme Court, based on the case of Harvella Investments and the Royal Trust Company of Canada, which is a 1986 appeal case at 207, to see whether it would be appropriate and possible and convincing to persuade the court that there are situations where what looks like an offer in the context of a unilateral contract is in fact a contract in its own rights. I'm not advancing that argument now. I'm merely adverting to the fact that there is House of Lords authority touching on this, which is not in the bundle, and on which no argument has previously been addressed. As I say, I'm not suggesting that is the right analysis. I'm simply saying that if we had had more notice, we certainly would have wished to consider responding on that. Second point, though, in relation to this approach, if, even assuming my learned friend's analysis is correct, and the non-disclosure agreement, when signed, essentially constituted an offer by Harcus Sinclair LLP, which was only accepted and therefore became contractually binding when confidential information was disclosed. On that analysis, the consideration moving to the covenantor was the litigation pack, as it was called. And that becomes important when we are applying the restraint of trade doctrine, because one of the questions that the courts invite attention to is the quantum of consideration. So it's important, let's assume, I'm not accepting, but let us assume for the sake of argument that my learned friend's analysis is correct. One has to follow through the consequences, and we will do that. But I just want to park that thought with you now, that if this is to be treated as a unilateral contract, what that means is that the consideration moving from your lawyers to Harcus Sinclair is the provision of the litigation pack. So when it comes to evaluating that part of the restraint of trade doctrine, the restraint of trade test, under which the court has to evaluate the quantum of consideration moving, one just has to remember that that is not the approach the judge took. In a sense, this is no criticism of him, because this was not the analysis of the contract that was offered to him. But when he was analysing whether or not this was a contract that was reasonable between the parties, he did not evaluate the quantum of the consideration moving by reference to the litigation pack that was handed over under this non-disclosure agreement. He was evaluating the value, so to speak, of the bargain by reference to the process of collaboration, informal collaboration that subsequently developed. So, with the greatest respect, even assuming my learned friend's analysis is correct, it is not going to affect our criticism of what the judge did, nor is it going to affect our submission that this is a contract under which the restraint is so out of proportion with the quantum of consideration moving to the covenantor that the court is driven in our submission to the conclusion the Court of Appeal reached, clearly, as it said, that this is a contract which is an unreasonable restraint of trade. I don't think anyone has yet addressed you actually on the content of the litigation pack, as it's called. It is in the bundle, or at least the relevant bits of it. There are some very bulky bits which are sort of public source materials. I'm not going to ask you to go to it, but I will just give you the page references. It's in the appendix part 2, and it's between pages 2440 and 2497. This is no criticism of your lawyer's work product at that stage, but it is absolutely fair to say that the material disclosed at that stage is very early stage, very high level, and not particularly detailed, and a lot of it is public source. So having clarified that, and just looking back at the content of the non-disclosure agreement itself, as I imagine you are already well aware, the points we make about what it does and doesn't do are, can be listed as being, first, that it is not a contract of retainer between a client and a solicitor. Harcus Sinclair was not being engaged under the terms of this agreement to give any legal advice. And secondly, Harcus Sinclair, your lawyers, was not committing itself to obtain any legal advice. There was a possibility that legal advice would be sought, but there was certainly no commitment to obtain legal advice, let alone legal advice of any particular level or value.
Mr. Crowe, I think Lord Burrows has a question for you.
Oh, I'm sorry.
Yes, it may be that you're going to look at this because you've taken us back to the agreement. But my question was going to be this: if this is not a unilateral contract, what exactly is your analysis of how it works? In other words, what is your lawyers promising to do, if anything?
I think the answer would be that your lawyers is not promising to do anything if it isn't to be treated as a unilateral contract. I can see that, and in a sense, that's part of our concern about the reasonableness of the arrangement.
So why is it contractually binding if your lawyers? What's the consideration then?
As the same law, that is the issue that hasn't previously been argued, and overnight we haven't got a concluded analysis either to accept or to challenge the unilateral contract approach. I think
what I'm putting to you is, if it isn't a unilateral contract analysis, but you are saying it's contractually binding on both parties, on what basis is it contractually binding on both parties?
Sorry, my lord. On what basis? Sorry, so that's as a repeat of the question, so to speak. What's the consideration?
Yeah.
Yeah, I suppose so.
No, sorry, that wasn't wasn't meant to be a dig. That was meant to be a clarification.
I think I'm saying is I've not got the answer from you that I'm looking for.
No, fair enough, my lord. As I say, I mean, we don't. I don't have worked up answers on this because it isn't something that we had to think about until yesterday afternoon. I don't know if my Lord Breeze is going to ask a question or answer the one that I was just asked.
I was just going to ask one actually. You elegantly seek to land the blame for this all being half thought through, even in the Supreme Court, on your opposing side. But did you ever plead that this was not a contractually binding undertaking?
I think the answer to that is no, but I can't pretend I'm fully on top of the pleadings. So can I have that checked and we can get back to you on that?
I mean, I don't want to make this too technical a question, but my impression at the moment, subject to correction from you, is that at no time has non-contractual because no consideration ever been part of the defence to the enforcement of the undertaking. And in a sense, this question, which I think Lord Burrows raised for the first time yesterday, is, well, if that's not in dispute, it must be a unilateral contract.
I can see the force of all of this, my lords, I will confer over the short adjournment. I mean, from what I do recall, I don't remember seeing any argument or any ruling in the courts below on the basis of an assertion that it was not contractually binding for want of consideration. But as I say, I can't pretend sitting here to know the pleading sufficiently to say with certainty that that is the case. Can I revisit that?
Yeah, of course.
As I say, after the short adjournment. So where I had been was simply to enumerate various features of the NDA, of the contract. It contemplates the possibility of seeking legal advice, but doesn't involve a commitment. It contemplates the possibility of confidential information being disclosed, but it doesn't commit your lawyers to disclosing any particular quantity or value of confidential information. So one it has to bear in mind when analysing, as at the date it is made, that the reasonableness of the 6-year non-compete covenant has to be assessed in circumstances where there is no contractual commitment on the part of your lawyers to disclose confidential information of any particular significance. And as I've said already, the other thing that the contract doesn't do is it does not commit your lawyers either to collaborating or even to negotiating a collaboration agreement. And I've already mentioned, and it is relevant here to repeat, the fact that the judge, the first instance judge himself, said in paragraph 76 of his judgment that when the non-disclosure agreement was signed, everything was up in the air. Anything could have happened. In principle, some confidential information could have been handed over. Your lawyers could have taken a dislike to Mr. Parker's response to it and simply walked away and entered into collaboration with Slater and Gordon or Lee Day or Erwin Mitchell, whoever else. And if that is what had happened, the 6-year non-compete would have bitten, and Harcus Sinclair LLP would have had no contractual entitlement to object to your lawyers going off and entering into a collaboration agreement with some other firm. So what the contract doesn't do is as important as what it does do, in fact, probably more so, when assessing the application of the restraint of trade doctrine. And as I also pointed out, the position of your lawyers in the court below, and I mentioned paragraph 88.4 of their skeleton argument, their position, their avowed position was that there was no settled commitment to collaborate. That's page 2392 of the bundle. That is just the sort of the contractual introduction. Can we just spend a few minutes looking at the law? And again, I hope to do this by simply telling you what we say the law is and telling you where to find it, rather than spending too much time actually in court turning the pages of law reports. I think there isn't a significant amount of difference on the headline principles, but there is some considerable difference on some of the points of detail as to the application of the doctrine on restraint of trade. So can I just run through the points on which we seek to rely and take you to at least some cases just to emphasize them. The first is the point which I think is not in dispute, which is that the restraint of trade doctrine involves a two-part test. Is the covenant reasonable as between the parties? And secondly, is the covenant reasonable in the public interest? Second proposition, we submit that the case law is absolutely clear in showing that the test of reasonableness as between the parties can only be satisfied if the covenantee can prove that the covenant provides no more than adequate protection to his legitimate interests. And that test clearly has two elements. One is legitimacy of interest, and the other is the test of no more than adequate protection for that legitimate interest. Can I just pick up a couple of the cases just on that point, because it is an important element in the outcome in the Court of Appeal. We can just have a quick look at Herbert Morris and Saxelby at page 1245 in the bundle. I don't think this passage was read to you yesterday. It's in the speech of Lord Parker, and he's discussing here the speech of Lord Macnaghten in Nordenfelt. In the first complete paragraph on page 1245, he says, "It will be observed that in Lord Macnaghten's opinion, two conditions must be fulfilled if the restraint is to be held valid. First, it must be reasonable in the interests of the contracting parties, and secondly, it must be reasonable in the interests of the public. In the case of each condition, he lays down a test of reasonableness. To be reasonable in the interests of the parties, the restraint must afford adequate protection to the party in whose favour it is imposed." And then he goes on in the next paragraph to say, "With regard to the former test, I think it clear what is meant is that for a restraint to be reasonable in the interests of the parties, it must afford no more than adequate protection to the party in whose favour it is imposed." And that is going to be a particularly important element, because one of the aspects of the restraint in this case, which the Court of Appeal identified in paragraphs 82 and 85 of its judgment, was the 6-year duration of the non-compete in this case. So that's Herbert Morris and Saxelby. I may not need any more, but it's a point we just pick up in Petrofina and Martin, which is going to be the relevant passage is at page 1624 in the bundle. this was one of the many solus agreement cases that occupied the courts in the 60s and 70s. And if we just look at page 1624 between letters B and C, you'll see that the quotes given in the speech of Lord Diplock and the judgment of Lord Diplock, where he says the test of unreasonableness, just above B, the test of unreasonableness has been expressed in a number of different ways, but most helpfully, I think, and he actually cites Lord Atkinson in McElstrim as being whether it affords no more than adequate protection to those interests of the private parties concerned, which they have a right to have protected. And I just
Mr. Crowe,
Mr. Crowe, I think.
Oh, sorry.
Question.
I'm assuming you place in quite separate reliance on the concept that the legitimate interest is an interest which you have a right to have protected.
Yeah, I was going to address that one separately. You're absolutely right. I do. I'm just looking at no more than adequate at the moment. There's one case I just want to use as the link between that point and the point you just made, my lord. Very briefly, Esso and Harper's Garage. If we can just look at a couple of short passages, another of the, as you know, of the solus cases. So this is going to be the judgment starts at page 929 in the bundle, but the passages I just want to take your draw your attention to three very short passages. So page 960. Very top of page 960, Lord Reed says, so in every case, it is necessary to consider first whether the restraint went farther than to afford adequate protection to the party in whose favour it was granted. The same point over the page, page 961, again right at the top, again, whether or not a restraint is in the personal interests of the parties, it is, I think, well established that the court will not enforce a restraint which goes further than affording adequate protection to the legitimate interests of the party in whose favour it is granted. And if one needed it, one gets the same again at page 971 in the speech of Lord Morris. Right at the bottom of 971, the last three lines. The last case I just wanted to go to on this point touches on this, but also spills over into the point my Lord Briggs just picked up, which is the legitimate interest point. And it's the case of Office Angels, which is in the authorities bundle starting at page 1454. I don't think my learned friend took you to this yesterday. It's a decision involving former employees who'd been employed in a recruitment agency under contracts which imposed both non-solicitation and non-competition. And two employees left. They started work for another recruitment agency. The first instance judge dismissed the application for an injunction to enforce the non-solicitation clause, but granted an injunction to enforce the non-compete clause. And the question in the Court of Appeal was whether or not the court should uphold the non-compete injunction. The nature of the business, just before we look at the thinking, what's material to keep in mind is that the nature of the business of the recruitment agency involved the recruitment agency itself establishing relations with employers who might want temps and with a cohort of temps. So there were both clients and potential employees. And one of the important things, and this is why I want to take you to it, and why it provides a link into the next topic, which is going to be the legitimacy of the interest protected. What this case does very clearly is to demonstrate that if a contract makes clear what is the interest that it is purporting to protect by a restrictive covenant, then the covenantee is not entitled to come along to court and try justifying the reasonableness of the restriction by reference to some other supposed interest. If we can look at page 1457. We find that the link. So at the very bottom of the left-hand column, paragraph 20, you see that the court, and this is in the judgment of Sir Christopher Slade, he encapsulates the principles of law in the right-hand column, and we don't need to pick up anything until in the right-hand column, in the right-hand margin, para 25. If, however, the court is to uphold restrictions which a covenant imposes upon the freedom of action of the servant after he's left the service of the master must satisfy the court that the restrictions are no greater than are reasonably necessary for the protection of the master in his business, and he cites authority for that. As Lord Parker stressed in Herbert Morris and Saxelby, for any covenant in restraint of trade to be treated as reasonable in the interests of the parties, it must afford no more than adequate protection to the benefit of the party in whose favour it is imposed, Lord Parker's emphasis. And then he goes on to say this, which is important in our submission. As the Deputy Judge rightly appreciated, these principles make it necessary to identify with some care the advantage or asset inherent in the plaintiff's business, which it asserts can properly be regarded as being, in a general sense, its property, which it asserts that it would be unjust to allow the defendants to appropriate for their own purposes. He accepted the plaintiff's submission that it had the right to protect by the imposition of an appropriate covenant two classes of goodwill, namely A, its goodwill arising from the creation of a client base of employers, and B, its goodwill arising from a secretarial base of temporary workers. And then we can pass over, and I'm going to pick it up again on the page we just turned on to, page 1458. In the right-hand column, paragraph 33, I revert to consider the nature of the trading connection which clause 45B was designed to protect. There was unchallenged evidence at the trial that in the plaintiff's organisation, a personal relationship will frequently develop between a branch manager, such as the first defendant, and employer clients or representatives of such clients. It's therefore not improbable that if a branch manager moves to another firm, a number of such clients will wish to move with her, and she'll wish to bring them with her. Likewise, there was unchallenged evidence that a personal relationship will frequently develop between a temporaries consultant, such as the second defendant, and persons who are in the habit of seeking temporary employment, so that if she moves to another firm, a number of such persons will wish to move with her, and she will wish to bring them with her. So that's the context. We just go over the page then to page 1459, paragraph 38, in the right-hand column. His Lordship said this, right in the middle of the page, para 38. On the wording of clause 4.5b, one important question, however, still remains to be answered. Having regard to the manner in which clause 4.5b was expressed, is it open to the plaintiff to assert that the relevant covenant was imposed for the purpose of protecting not only its trade connection with its employer clients, but also its trade connection with its pool of temporary workers. In a case where the wording of a covenant restricting competition by an employee after leaving his employer's service does not specifically state the interest of the employer, which the covenant is intended to protect, the court is, in my judgment, entitled to look both at that wording and the surrounding circumstances for the purpose of ascertaining that interest by reference to what would objectively appear to have been the intentions of the parties. However, in a second category of case, where the employer who proffers the covenant for the employee's acceptance chooses specifically to state the interest of the employer which the covenant is intended to protect, the employer is not, in my opinion, entitled thereafter to seek to justify the covenant by reference to some separate and additional interest which has not been specified. An employee who is invited to enter into a covenant of this kind may wish to take legal advice as to its validity and effect before he accepts it. His legal advisors will, in my opinion, be entitled to give him such advice on the basis of the stated purpose of the covenant, if any such purpose is stated. In my judgment, the present case falls within the second category. Both the covenants imposed by clauses 4.5a and b are preceded by introductory words, and he then sets them out and explains why that contract specified the interest that the covenant purports to protect. And if one then looks at paragraph 43 on the next page, his lordship concluded by saying, in my judgment, therefore, if the covenant in clause 4.5b is to be justified at all by the plaintiff, it must be justified on the basis that it affords no more than adequate protection as regards its trade connection with its clients. Since, in my opinion, the Deputy Judge misdirected himself as to the construction and effect of the covenant, this court is, in my opinion, entitled and bound to consider anew its reasonableness or otherwise, unfettered by his conclusion as to its reasonableness, but of course, having regard to his other findings of fact. My lords, my lady, that is all I wanted from the citations in that case, and I notice the time, if that's convenient.
Certainly. Thank you, Mr. Crowe. We'll resume at 2 o'clock. Thank you very much indeed.